over the phone using video, and this is wonderful. So let's talk today about international intellectual property protection for small entities, and also it's valid for large entities and individuals. My background is the following. I was born in Russia in St. Petersburg and graduated from St. Petersburg University Physics Department. I have PhD in physics, in laser physics. And that's how I came to United States. And then I chose profession of intellectual property attorney. And I have my own firm called Patent Hatchery. You can see it here. And if you are interested in our website, here it is, us-patent.ru. So this is our website, and you are always welcome to visit it and ask questions through our website if you have any after this presentation. We are located near the capital of the United States in Washington, D.C. And I hope that I have such a strong Russian accent that everyone understands me in Russia. This is okay in the United States, you know, this country accepts any accent. So do not hesitate to speak. It's much more important to speak. As Jane said, we are here to practice. And please ask me. I would really happy to answer, and I would really happy to have our communication interactive. All right, next slide. Mm-hmm. So, well, just a few words about Patent Hatchery company. We are working with 54 countries of the world, and I was giving lectures at least in half of them on the intellectual property. We have partners, so we have quite an experience in working with many countries and adjusting our mind to specific national laws of intellectual property of different countries. I must say that in general, intellectual property laws are quite the same, but there are some peculiarities that we would like to discuss, and that's what we are going to talk today. All right, next slide. When we're talking about intellectual property protection, many people have some kind of confusion about the role of intellectual property. It's actually not about you, the owner of intellectual property. It's about others. Others means that it's to exclude others from selling and using, making, and having any kind of profit out of your intellectual property. It's not about you. Well, it is about you being the first, yes, but it's not really the purpose of intellectual property. The intellectual property is a part of business. This is very important. It's a part of sales. So to exclude others from sales, from getting money out of your property, this is the purpose of filing for patents, trademarks, and copyright. Everyone knows that there's one more type of intellectual property, which is called trade secrets. And famous example is Coca-Cola, that keeps trade secrets for more than 100 years now. And they succeeded. They actually were able to keep those secrets. However, it's very, very risky, really risky. I mean, if a key person, key engineer leaves the company and he knows the whole process and he knows each and every part of your technology, it's very easy to start his own business or to go to another company and be hired in another company, and the trade secret will be shared with your competitor. And this is not good, of course. And we have multiple examples of leakage of trade secrets to competitors. So I would not recommend it unless you need it to use trade secrets. All right, next slide, please. So you have invention. No, wait. You have invention. And as I said, the purpose is to get money out of this invention. Okay, next. So the first way is to get a patent and then to license it to some integrator. We call them integrator. It's a big company, for example, Boeing or Lockheed Martin or whatever, and then get money out of licensing. It can be exclusive license, it can be non-exclusive license, it can be sale, even not, okay? So, but there is some other ways how to get money out of your invention. Next. So you can start your own startups and then you grow, like all these famous Silicon Valley startups like Hewlett-Packard started in garage, or Google started in garage, and see where they are now, $1 billion company. And this happened during our life. I mean, it happened in like 20 years. So this is the way to go. Unfortunately, it's kind of rare. it's not that easy to grow $1 million company out of your idea. So the next way to do is, when you have startup and you have patents that protect your technology, you can sell company that has already like a sample pilot product and also patents to the big company like Boeing, like Google, like whatever, Autodesk. This, I would say that this is the best way to go and the most practical, because selling patent by itself is the task of the whole life. Like the first, you see the first way, like you have a patent and then you license it. This is typical way for universities. If you did your invention in the university and you have the whole OTT department, Office of Technology Transfer Department, and there are specialists working in this department who will sell it, who know connections to some biopharm companies that are interested in this kind of specific drug that you are developing, and they can license, and you get like 1/3 of this license fee as an inventor. The first way, like patents, license, and money. But for real people that do it yourself, the typical way of getting money is to make your startup, your small company, and today we're talking about small entities, right? Small companies, and then sell the company for, say, $5 million, $10 million, $100 million to Hewlett-Packard. And this is very real. This is what's happening every day. So that's different ways how from your invention you can go to getting money, because this is the purpose of intellectual property. And all these ways include what? Patenting. Next slide. So patenting is a key success for any way to go from your invention to money. And we found like we looked at 3 different paths. And according to very famous Economist magazine, up to 75% of the company value is in its intellectual property. A lot, right? A lot. All right, let's make a picture of our meeting. All right, so next, please. Итак, what we have patents. And what kind of patents? Patents, utility patents, protect processes, materials, devices. These are real patents for inventions. They are called in English utility patents. And another type of patents is design patents. And let's not forget about those type of patents. I recently read an article by Kaspersky, Natalia Kaspersky, wife of famous Kaspersky company. And she said, Tesla, and I own Tesla car, and it hurt my heart, really. She said, Tesla did not have any technical patents. All patents that Tesla has is for design. What the only invention that Elon Musk made is on design. Okay, if only invention that Elon Musk made is on design, look at the value of Tesla company, and it is now #1 in all automobile industry. It costs more than Toyota, Tesla, only because, as Natalia Kaspersky said, only because of design. So do not appreciate design patents, okay? And remember the famous case between Samsung and iPhone about this shape of iPhone corners. They are rounded. So it was, I think, like $1 billion deal that Samsung infringed iPhone patent, design patent. So again, pay attention to design patents. Copyright. Copyright is, in Russian, авторское право, is a type of intellectual property when you protect your book, your artwork, your, by the way, your software, or your, for example, design of your electronic circuit. It can be protected by copyright. Trademark. When we talk about trademark, and I must tell that most of my orders from Russia, and I have hundreds of orders per year from Russia, are about trademarks. So when you are selling here in United States, say on Amazon, you need to register trademark. And we specifically can talk about that, how to register, and then how you get identification on Amazon. So yes, you need to register your brand name so nobody else will use it and sell their product, the same product as yours, under your name, and take a part of your income, of your profit, by selling the same stuff. Next, please. All right, so here are some examples on the left, how you find out which patent is utility patent, which is design patent. When you see the number, first patent number, you have US, this is for United States, and you have first 2 letters for each country. For example, for Russia, it will be RU, for Europe, it will be EP, and so on. So this is typical patent for inventions. And when you have design patent application or patent, you have the letter D in front of the number. That's how you find that this is about design. And talking about trademark, how does it look? There are two types of trademark, mostly, mainly. One is the word trademark, which is just a word, and another one is an image. It can be simple image, it can be colored image, it can be 3D image or whatever. Here, an example of just simple word mark, and each trademark is registered in specific technical class. Say, here we have optical metrology apparatus, class number 9. And each trademark can be registered in a number of classes. And it cannot be descriptive. For example, you can register, not you, but you know who, registered Apple for computers, but it is not possible to register the word apple for selling fruits because it is descriptive of what you are doing. So it must be some kind of unique name for this specific type of product that you are selling, okay? Well, and talking about copyright, we are talking mostly about books. That are our main orders, that people write books or illustrated books, and we submit them to Library of Congress in United States and get registration for copyright. Copyright protects the whole thing and each part of it. So if in your book you use drawings of somebody else, they need to be excluded from copyright. This is important thing. Next slide, please. Okay, and we will talk a lot about patents and patent structures, claims, description, and drawings for utility patent. And talking again about design patent, we're talking about novel design, novel shape. And the most important part of the design patent application is lots of drawings, and it must be front, back, left, right, up and down, from top on the bottom, and isometric view. So that's how design patent is submitted. Okay, next slide, please. Again, more. So, and here example of my book, which was bestseller for quite a number of years, and it is intellectual property in academia. Since I actually came from university background and university sciences and engineers are my colleagues for many years, so I wrote this book based on order from publishing house, Taylor and Francis, a very famous publishing house in California. So main questions that we always need to ask ourselves before jumping into this ocean of intellectual property. First, is it novel what we invented? It needs to be novel for everyone in the world, not just for you. Like Vinokur, when he was performing попутная песня Глинки, said, исполняется впервые. Everyone asked him, why впервые, почему впервые? Он говорит, мною впервые. Так вот, innovation must be novel not just for you, that you do not know anyone else who did it. It must be novel in principle. It must be novel in all database in the whole world. And the second question, do you own it? It's kind of easy. Yes, I invented it. Yeah. Well, it's not that easy. If you work at the university, it belongs to the university. If you work in the company, it belongs to the company. And in some cases, even if you invented it at home in your laundry because you wanted to fix your laundry machine, it still belongs to the university because the university contract says that anything that you invented being employed at the university belongs to university. It does not matter what you, if it is related to your field or not related to your field, especially in Japan. For example, Japan are very, very strict about it because very, very often it's very hard to find the difference between what is your obligation at work to provide and what is not. For example, you work on specific drug at the university, on medicine, and you invented a different medicine because you're working on this one. You came with a new idea, but you came to this idea because you were working at the university, because you had this equipment. That's why it is very hard to split. It is not fair that you will file by yourself a patent and get profit on this another drug that you invented because it's related to your specific work. So many universities and many companies say, for example, Google, if you are at Google, anything what you invented belongs to Google. Shh, everything. Okay, so this is the second question. The third one, is it profitable? This is extremely complex question. So I invented something, so how much money I will get? What is the market niche? How many companies will buy it? So this is the whole theory and the whole, the presentation has disappeared on my screen. У меня исчезла презентация.
Just a second, fixing. Just a second, it will be back.
Да. So what I'm talking is about profitability, right? To make your invention profitable. Because it doesn't make sense if you need to spend, say, $100,000 to move forward with your invention, and then you get in return 50,000. All right, so you need to understand. Do you need a protection, or you just you're working in the hospital, you invented some improvement for some medical device that used during the operation, and you come to a special whatever equipment department in the hospital and say, can you produce it? So it will be like small entity inside the hospital that will provide this small amount of like scissors or something for operations, but for this specific type of operations, and there are only 100 of them needed in the world, or 1,000. So maybe it does not really require protection, and what kind of protection? And then how I patent it. This is kind of easy. If you already responded to everything, we can help you with patent it. Next, please. Next slide, please. Yeah, the history of patents is very interesting. Even before Christ, actually, there were culinary competition in ancient Greek that led to the winner who can have exclusive rights to make this dish for a year. It's like a patent. Yes, very interesting. And of course, in medieval times, it became very popular, though it was much more official. The patent was signed by a queen or by a king, or you know, it was really, really great thing to have. Mostly it was given to suppliers of the king, something for kings. For example, like stained glass, витражи или еще что-то. So this was given. So history of patents goes back to medieval age when it became quite popular. Next slide, please. This is for us now very important. So I would recommend the most, if you want to look for similar patents or have any questions on patents, it's in the bottom of the slide. This is Google Patents, google.com patents. The best browser to find relevant patents based on keywords. This is my favorite. And of course, we often use USPTO, the top United States Patent and Trademark Office website. This system is transparent. Transparent, I mean, for each and every US patent, you can see every document that was submitted for every patent. You can see all communication, each and every part, all steps, everything what happened during the prosecution, during the life of patent, so it's absolutely transparent system. That's why we like it. Here is the link to European Patent Office, and here you can find practically all patents from the whole world. Okay, next slide, please. Requirements for the patent are well known. It must be novel, we already discussed, novel in the world. It's not like you went for the nice trip to Thailand and despite of all beauty of this country, you found some kind of knife that you never see before. So you go back to your country and file patent for that knife. No, 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 it doesn't work. It's not novel, you did not invent it. So second, it must be useful. And here we come to example of, for example, software. And very often I get some applications for, it's the best way to optimize any kind of algorithm. No, no, no. I need to touch something. It must be useful for something. It's a good way to optimize, to optimization of algorithm of three-dimensional building houses or whatever. It cannot be abstract. It must be really useful for something. And non-obviousness, неочевидность, is the most complex thing because invention must be not obvious for person who actually works in this field, who engineer, who actually got education in this field. And it still needs to be non-obvious, неочевидным, for that makes an invention. Invention cannot be obvious. For example, if you put something on heat, it will raise the temperature. It's obvious. But if you put something on heat and it actually cools, oh, this is non-obvious. This is invention. This is what means non-obviousness. I like an example of children загадка. Чем больше нас, тем меньше веса. What? Чем больше нас, тем меньше веса. Well, this is дырки в сыре. So this is kind of non-obviousness because you expect the more you have, the more weight it is. So this is a good example of non-obviousness. Next slide, please. I would like to talk about a very specific thing that exists in the United States and does not exist in Russia and other countries. That's why I have to explain it over and over again to my clients. This is called continuity applications. Continuity patent applications create families. So what is continuity application? You have patent. Not patent, you have application. You have patent application. By the way, this is the view of US patent system that everyone can see. So you have this patent application, method and system for nuclear substance revealing using muon detection. And then you get allowance, means that in 3 months you have to pay issue fee and issue this application, заявку, as a patent, okay? And before paying an issue fee, you create a daughter application. So there is mother application, I create daughter application, but daughter application must be born, must be submitted before mother application is issued. And daughter application can have additional improvement, a little, maybe more, a little improvement over mother application. For example, you add cooling system, систему охлаждения, or you add feedback loop for adjustment of parameters, or you do something that did not exist in mother application. So you add it to daughter application. It's almost the same, but with this additional feature. Or you have certain drug, medicine, and you add additional component to fight nausea that this drug causes, right? Or some other side effects. So you add a little thing and you file daughter application. And once daughter application is ready to be issued as a patent, before issuing, you file granddaughter application, внучатую заявку, and so on. So you create like a chain of applications. Each one is improvement of the previous one. And since daughter application was filed during the life of mother application cannot be used against daughter application for rejection. That's how you create the whole bunch, the whole family of applications. Next slide, please. So what are patent limitations? No, of course, everyone knows that patent exists 20 years and there is not much you can do about it. This is the exclusive right to use it in business is given for you in exchange of giving it after that to mankind. You give it. The scope of the patent is in its claims only. So actually, the most important is part of the claims of patent are claims. Only what is in claims belongs to you. That's why writing claims is a specific art and is the main task of the patent attorney, what to do. You need to know that patents are published 18 months after their submission. So you cannot see them for 18 months. So you have to check relevant competitor patents now and then to find out what happened, because they will be published now, but they were submitted 18 months before. There is such thing as non-publication request that some of inventors use. It means that application, as long as it is application, will not publish at all. Only when it is a patent, then it will be published, and then you can see it. All right, next slide, please. It is important to know that patent protection is national, it's territorial. So there is no such words that we in Russia have this patent and Americans took it from us and now produce their products, but we have this patent in Russia. No, no, no. Everyone can produce your device, your medicine, your whatever component, if you patented it in Russia and protected in Russia, so everyone else can produce and sell it in Germany, China, United States, Australia, anywhere. And vice versa. If you find somebody's patent in United States that you like, and this person or company did not patent it in Russia, you can take it, you can produce it, you can sell it in Russia, and this is absolutely legal. So there is no infringement, no legal actions from one country to another. If you like somebody else's patent in Norway, say, do it in Russia, you know, please do. Okay, this is good to know about international approach to patent filing. If you plan to sell it and produce in China and sell in Germany, you have to file patents in China, in Germany, in Russia. Okay, next slide, please. There is such thing as international patent application, or so-called PCT application for 152 countries. And being in Russia on multiple conferences, I'm laughing when they say, we have international patent. I said, what? We have PCT application. What? International patent? There is no such thing as international patent. There is such thing as international patent application, which never becomes patent unless after filing PCT application, which is really valid in 152 countries, unless after that you actually file it in the countries where you are interested to get a patent. For example, United States, Germany, China, Australia, Japan, whatever. So again, PCT application is a certain tool, an instrument to get examination which may consider examiners in different countries. It provides like universal examination for your invention. If PCT examiner, Patent Cooperation Treaty, PCT examiner, finds your invention not patentable and shows multiple examples of international documents that prevent you patenting, and then you go on national stage, for example, in Europe, examiner in Europe will see everything what PCT examiner did. So they will immediately see all rejections that were made. But if PCT examiner thinks that your invention is patentable, you're in a good shape. It's probably patentable, at least in some countries, but examiners of each country will examine it again. Next slide, please. Here's how this international patent application looks like. It has WR before the number. So it's World International Office. And again, it is only application which never becomes patent. Next slide. I very often get questions about software patents. Software patents exist, though it is very hard really to get those patents. Really, there are so many restrictions and so many rejections related to software patents that you have to be prepared. Fighting for software patents is the most expensive thing what we have. The general rule is software patent must have, first, something novel in the structure. Just using computer and server and keyboard and display really does not make invention from technical point of view. So it is good to have, for example, I remember we won the case when we had ability to make corrections in the document simultaneously from different computers. This was novel, that not just one person can make corrections, but two simultaneously. Things like that must be novel. Alternatively or additionally, if your invention has unique use, for example, your software allows to make a transformer. Your chair becomes a dinosaurs, dinosaurs becomes flat carpet becomes chair, a chair again. So this kind of practical things that did not exist before. Nobody before transformed chair into dinosaurs and dinosaurs into flat carpet. So this makes software really valuable, patentable. Okay, next slide, please. So talking about international approach to filing, usually people submit patent application in their own country and then file PCT application on 152 countries, and after 30 months file national application in different countries like United States, Europe, China, and so on. These are typical three actually national stage entries: United States, Europe, and China. United States because still 50% of high-tech market are in United States, China because usually production is in China, and Europe is very close to Russia, and Russians like to have connections and economic relationship, business relationship with European countries. Sometimes when it is just a limited amount of countries, people file national stage applications in Russia, and then in other country, for example, in United States, because this is the only market that we see. Or only if it is like oil and gas industry, only in countries where there's a good oil and gas. There is no interest in filing it, say, in Germany, which is a very good country for business, but there's no oil and gas industry there. And almost never just filing PCT application right away and then national applications. Next slide, please. When you're working with foreign countries, you actually have to hire practitioners, attorneys in each and every country where you're working with. And this is very, very expensive. For example, the lowest hourly rate in Europe is about 300 euro per hour. 300 euro per hour. So for preparing, say, some office action response, attorney will need 4 or 6 hours as a minimum. And this means thousands of euros for you. So be prepared when you're working with different countries, you are paying fees that are required in those countries on hourly rate. And I was surprised how expensive it is, for example, in South Korea. It's extremely expensive. So, and in Japan. All right. So next slide, please. Now we are entering practical part that I can discuss or not discuss, and we're already talking now for 15 minutes, and I suggest we have 10 minutes for questions now to complete our 1-hour lecture. So I would like to stop now. Thank you very much for your attention, and I really would like your feedback, and ask me. I don't know if your host, Jane, will allow in Russian, but I would prefer if you ask in any language, but just ask questions and let's talk about international intellectual property. Okay.
Yes, everyone can turn on their sound right now and ask questions by voice, so no problem with that. But we have some participants not from Russia only, so I ask you to try to speak English, but whatever, if you would like to ask in Russian, I will translate simultaneously, no problem. So chat is open. You can turn on the
My
voice.
first question, do you understand my English?
I do. So please provide some feedback.
Are there any words that I used, Jane, that you did not understand?
I got everything.
You got everything.
Yeah.
Good, good.
Yes, so we also have.
Oh, Galina also said that she understood everything. I think this is because my strong Russian accent makes me pronounce it almost like it is written. All right, so what else?
I have a question. It's concerning actually trademark and some issues of the US market, because when a person has a trademark, the owner of this trademark has to prove the usage of this trademark every 5 years. And so we now have a client who has to prove such a usage. And he asked me if he provides, for example, screenshot from Amazon that their products are really sold to the United States market. Can that be a proof?
Absolutely. This is the best proof. Mm-hmm. If you sell it on Amazon, this is absolutely the best proof. You just provide us screenshot. Additional thing that we need is the date of the first use in United States and the date of the first use in Russia. And it should be specific date, like 27th of April of 2003. Mm-hmm. But there is no confirmation required. We do not need any documents to confirm the use. We just need the date.
But it was a national trademark, so it's not a Madrid system. So just the United States first usage date, I guess.
Most of the time, Russians submit Madrid Protocol trademark to different countries, and for Madrid Protocol trademarks, there is no confirmation of use for the first 5 years. For example, you submitted in 2000, in 2005, you need to prove that you started using it in United States. But if you directly file it in United States, you need to, without Madrid Protocol, you need to prove the use of the trademark right at the time of registration of the trademark. So we can submit trademark application in United States either with when the use is already started. So we need to provide proof that it is already started. You already put it on Amazon or your website or somehow, and we provide a document, a screenshot, and say it's already used as of 20th of April 2021, okay? Or we submit application with intention to use, because we're afraid that somebody will actually, you know, fight our trademark. So we're saying, no, we are not using yet. We just intend, мы намерены использовать. And then we get allowance. Examiner says, yes, you can use it. You're allowed, nobody, you're not infringing anyone's trademark. So, and then you submit confirmation of starting of using. Then you submit confirmation of use. Actually, yes, here is my, and you are given 6 months window for that. So the 6 months that you submit documents that you started using it. And there's enough time to create your website. And it's not necessarily that you started to sell something, but it is offer for sale. Предложение к продаже is equal to use. So you do not need actually sell something. If nobody wants to buy, it's okay. But you offered. Но вы предложили продажи. Этого достаточно для... This is enough for confirming the beginning of the use. Did I answer your question, Jane?
Yes, thank you.
I saw 2 questions in the chat.
Hello.
Yeah.
Hello,
Yes.
good afternoon.
Yes.
Good afternoon, Galina.
Hello, yes. I have a question. We have a patent in Russia, but we plan to sell our production in China. So we need to have a patent in China?
Well, you will sell it there without patent. So everyone can actually copy and also sell it in China, right? So if you are okay with this scenario, then everyone can beat your business if you don't have a patent in China. But I'm afraid that you cannot file now patent application in China because you already have patent in Russia. Means it is not novel, because there is only window of 12 months between filing in Russia and filing patent application in China. And if those 12 months are over, so there is more than 12 months since you filed, you submitted patent application in Russia, there is no way you can get patent or file patent application in China. So there is actually no way to protect you in China now.
Yes, but we have an application in China. So when we receive a patent, we will protect, yes?
Yes. When you receive patent, means that no one in China can import this product, sell, produce, or do anything for the nearest 20 years.
20 years, yes. It's like in Russia, yes?
Well, 17, 20 years, it depends. But this is, it's all on Google, so you can find how long it works and from which date it starts, from date of filing or from date of issue.
Yes, it depends on date. I see. Thank you.
You're welcome.
Bye-bye.
Yes, and another question from
chat. Do you see it? Can you read?
Is it needed to have a patent to sell already made production when you made the product in one country where is no patents and sell in another where patent is? Well, where you don't have a patent, everyone can produce and sell your product. So if you're not protected in the country where you produce it, then everyone can also produce it and sell in that country. This is the answer. What you want to protect? I did not understand from this question what you want to protect. Your business in country where you produce it. My typical advice would be to have patent in country where you produce it, where you sell it, and where you export, import, and license. To have patent in all those countries. But I understand that budget is budget. You know, money is money. It's you do not have unlimited amount of money to do everything. Where the most important is to get patents where the market is, where you have buyers for your product. For example, I give an example of oil and gas industry. So if you sell oil and gas equipment, you actually sell it to the countries that produce oil and gas, right? You do not need to sell it to the countries which does not have oil and gas. So this is the answer. Is it okay, or do you need more clarification?
Actually, yesterday on our Russian section, we had a wonderful speaker who is the leader of Business Angels of St. Petersburg. And she told us how important is that to, let's say, to check that you have registered and fixed all your IP rights on the very first steps when creating, yes, your business, when you have a startup, because investors understand how important IP rights, how valuable are they before you start some production, before you share your ideas with someone else, and so on. So that was...
Well, of course I agree. Of course I agree by heart, because when it is not resolved from the beginning, it leads normally to conflicts. And when people have conflicts, they come to me and say, Nadia, now you solve the issue. I said, why didn't you come first to register it properly? And then there will be no issues and no headache and no this huge money spending on resolving the issue. I always recommend to have agreements in advance, at least written agreements, especially if, like everywhere in the world, people like to create companies together, like two friends, husband and wife, and so on. So when you create a company with your partner, you absolutely need to have an agreement who owns what and how it is shared. Because then, if and hopefully you will get profit, it is very hard to discuss how it is shared and who did a lot, who contributed what. So please make agreements in advance with partners and with suppliers who provide you something. For example, Other type of conflicts is somebody provide a specific important detail for example, electronic circuit for your device. And eventually they say, no, we will not provide you this circuit unless you pay us more. And you do not own this, and you do not have rights, and so on, so many business questions. So always set up, you know, agreements, IP rights, and everything in advance at the beginning of your business, of your endeavor.
Nadia, if people are quite busy or cannot handle with these agreements, which you just told us, can you help future businessmen with such kind of agreements, maybe with possible suppliers or between the partners who are starting the business?
Again, this is for each country is different, and there are so many of them on the internet.
Mm-hmm.
This is not for IP, of course, but for business issues, I would recommend business lawyers, which is different from IP lawyer.
For IP issues.
And what I recommend, any agreement is better than no agreement. Even if it is not perfect, go on Google, make your own, really discuss it, openly discuss this issue, and sign any agreement rather than no agreement. And this is cheap. This is nothing. I mean, for zero money, you make any agreement. Because common sense is the most important thing in this kind of business. Просто с точки зрения здравого смысла. Что и как, кому и... Of course, when you go about IP rights, you go to specialists. And of course, we are happy to help.
Just to prove.
Most often I have issues, not I have issues, but my clients have issues with partners that you hire in United States without agreement. Of course, Sergey from Brighton is such a good boy. We were in one class at school. He's such a buddy. Of course, we decided that we will send him our product and he will sell it in the United States. And then it turned out that Sergey absolutely not a very nice person, and he actually make all account of the company on his own, and he owns all money of the company, and he does not send money back to Russia, and so on. This is the most often case in my practice, how Russian companies hire their US representative in United States. And then it turned out that their representative actually registered trademark on his own name, not on the name of the Russian company, but on his own name. But, oh, he's such a good buddy. Okay, Sergey is such a good person. It's okay that he registered trademark on his own name. And then he actually throw you away and produce this product in China. And since he owns trademark, he sells a different product under your name, under your trademark name, because he owns it. And this is going on and on and on with all, not all, but many Russian clients that we have. Okay, so we are now, our 10 minutes, we're already more than 1 hour. Any more questions or anything?
Thank you.
Okay. Goodbye.
Okay.
Bye-bye.
So, I'm closing the
Thank you,
conference.
Jane.
Thank you. Thank you. See you. Bye-bye.